Think estate planning is just for the wealthy or too complicated to start? Think again. Protecting your family and legacy starts with one simple step. In this video, I'm going to walk you through 6 essential steps of creating an estate plan so you can feel confident and in control of your future. Hi, I'm Dr. Ray Gervasio. In 30 years as an attorney, I've seen families torn apart, wealth drained, and years wasted in court, all because of poor planning. We make sure that doesn't happen. If you want to protect what you've built and keep your family out of court, call me at 408-945-3950 for a free consultation. Estate planning is a crucial part of life, and it's a responsibility that ensures your legacy is protected. But where do you start? Let's go through it together step by step. Step number 1, list your assets and liabilities. The first step in creating an estate plan is to take inventory of your life. This means identifying your assets, liabilities, and everything in between. Creating an accurate and comprehensive list is crucial because it forms the foundation for how your assets will be distributed after your death. But what exactly should you include? Real estate. Begin with any real estate you own. This could include your primary home, vacation properties, land, or rental properties. Real estate can be one of the most significant assets in an estate plan, so it's essential to list all properties and their current values. Next, list all your financial accounts, including checking accounts, savings accounts, retirement accounts such as IRAs and 401ks, and life insurance policies. These accounts often make up a large portion of your estate and need to be factored into your plan. Be sure to include account numbers, financial institutions, and beneficiaries on these accounts. Digital assets. In today's digital age, it's just as important to include your digital assets into your estate plan. This could include cryptocurrencies, digital media files, email accounts, social media profiles, and websites you own or manage. Make sure to provide access details, passwords, and any special instructions for your loved ones to handle these accounts after your death. Personal property. Don't forget to include personal items that may have significant value, such as vehicles, jewelry, art, collectibles, or heirlooms. These are often the most emotionally valuable assets, and listing them helps clarify who will inherit them. Business interests. If you own a business or have shares in a partnership, list these as well. Business interests can be one of the most complicated aspects of estate planning, especially if your family members are involved or if you want to leave instructions on how the business should be managed or sold. Finally, it's important to list any outstanding debts you owe. This includes mortgages, car loans, credit card debts, student loans, personal loans. The values of your liabilities will affect how much your heir can inherit after your estate is settled. Step number 2, define your estate planning goals. Once you've listed your assets and liabilities, it's time to define what you want your estate plan to achieve. Estate planning is not just about distributing your wealth, it's about ensuring that your wishes are followed and your loved ones are cared for in the way you intended. First, decide who will inherit your assets and in what proportions. Some people may choose to divide assets equally, while others may have specific bequests in mind. For example, you may want to leave a particular piece of jewelry to a child or donate a portion of your estate to charity. Your estate plan should reflect these desires. One of the major reasons for creating an estate plan is to minimize taxes. Estate taxes can take a significant portion of your wealth, but with the right planning, you can minimize or even eliminate these taxes. Consider using tax-saving strategies such as setting up trusts or gifting assets during your lifetime. A tax-efficient plan ensures that more of your wealth goes to your loved ones, not the government. In the event that you become incapacitated, you will want to ensure that your medical needs are handled according to your wishes. You can specify how you want to be cared for in your estate plan through a living will or healthcare directive. This gives your loved ones clear instructions and ensures that healthcare decisions are made based on your preferences. If you have children, one of the most important decisions in your estate plan is choosing a legal guardian. Your estate plan should include provisions for who will care for your children in the event of your death. This is a significant responsibility, and you should select someone you trust to raise your children according to your values and wishes. Step number 3, draft essential estate planning documents. Now that you have your assets and goals defined, it's time to start drafting the essential documents that will make your estate plan legally binding. The most important documents you'll need will include a will. A last will and testament is the foundational document in any estate plan. It specifies how your assets will be distributed, who will serve as the executor of your estate, and who will take care of your children if applicable. Your will provides clear instruction for your family and ensures that your wishes are followed. While a will is crucial, trusts offer additional benefits and flexibility. Trusts can be set up during your lifetime, called a revocable living trust, or upon your death, called a testamentary trust. A revocable living trust allows you to manage your assets during your lifetime and pass them directly to your beneficiaries without going through probate. This can save time, money, and keep your estate private. Other types of trusts, such as special needs trusts or charitable trusts, provide additional benefits based on your specific goals. A power of attorney allows you to designate someone to manage your financial affairs if you become incapacitated. A living will, on the other hand, outlines your wishes for medical treatment if you cannot communicate. Both of these documents are critical in ensuring that someone you trust is able to make decisions on your behalf when necessary. Now, in California, both of these documents are in one document called an Advanced Healthcare Directive. Step number 4. Update beneficiaries and plan for taxes. It's crucial to review and update your beneficiary designations regularly, especially after major life events. This includes all financial accounts that allow you to designate a beneficiary, such as insurance policies and retirement accounts. If your estate is large enough, you may need to plan for estate and gift taxes. There are several strategies you can use to reduce your estate tax burden, including gifting assets during your lifetime, creating charitable trusts, or using generation skipping trust to transfer wealth directly to grandchildren. Step number 5. Review and update your estate plan. Life changes, and so should your estate plan. Whether you've had a major life event such as a marriage, divorce, birth of a child, or a change in your financial situation, your estate plan needs to reflect these changes. A good rule of thumb is to review your estate plan every 3 to 5 years, or after significant life events. Estate planning is one of the most important steps you can take to ensure your family is cared for after you're gone. By following the steps I outlined in this video, you can create a comprehensive plan that protects your assets, minimizes taxes, and provides for your loved ones. With the right guidance from a trusted estate planning attorney, you can create a plan that fits your unique needs and goals. If you haven't started your estate planning yet, or if you need to review your existing plan, give me a call at 408-945-3950 for a free consultation. I'll guide you through the process and help you create a plan that fits your needs. If you found this video helpful, don't forget to hit the like and subscribe. I'll see you in our next video.